Hello everyone, a very good evening. Welcome to Oliveboard. This is the CAIIB Foundation series for June 2025 exam, and we are discussing each and every unit from all the modules of our BRBL paper. Today we have module C, unit 18D, which is procedure of tribunals. So, this particular chapter, we are going to talk about how can an application be made to the tribunal, how the appeal to the appellate tribunal is made, what is the deposit of the amount of debt due for filing the appeal with the DRAT, what are the procedure and the powers of the tribunal, and the limitation or the time period for filing the application or appeal. So all of these videos are available on the YouTube channel. If you haven't yet seen them, make sure that you watch the previous videos as well. These are very important from an exam point of view. And also subscribe to the channel so that you do not miss any of the updates, the important updates till your final day of exam. So let us start. First, we have the application. So when a bank or a financial institution, they have to recover any debt from any person or entity, then they have to make an application to the tribunal within whose local limits the tribunal or the institution is working. So every tribunal's local limits or jurisdiction is decided by the central government. Accordingly, the financial institution or the bank has to file the application with the DRT, right? So what will be the next step? The next step will be the tribunal shall issue the summons to show cause within 30 days of the service as to why the relief paid should not be granted, then direct the defendant to disclose the particulars of the properties other than the properties and the assets which are already specified. The other properties and assets should also be provided the information related to them to restrain the defendant from dealing with or disposing. So now from the date the order is passed by the tribunal, the defendant now cannot sell off or transfer the property to another person, right? So the branch or any office of the bank or financial institution, that the place where it is maintaining an account in which the debt claimed is outstanding. This is going to decide the jurisdiction of the tribunal, right? And then the summons will be made. Okay. Also, the defendant can now not deal with the property under consideration. Okay. Then the next step will be within a period of 30 days. The defendant has to present a written statement of their defense. So the defendant will be given an opportunity to be heard. They'll be given a period of 30 days if they want to claim, they want to set off or a counter claim, and such written statement shall be accompanied with the original documents or the true copies with the leave of the tribunal. So if the defendant they wants to file a counter claim or a set off against the complaint that has been made by the bank or the financial institution, for that 30 days will be provided. If however the defendant they fail to file the written statement within this said period of 30 days, then in exceptional cases or in special circumstances an extended period will be provided, but this extending period shall not be more than 15 days to make the written application or written statement, right? Then if the written statement has been made and then the tribunal finds that it is just and convenient, then they can appoint a receiver of any property, whether before or grant of certificate of the recovery of debt. They can remove any person from the custody or possession of the property. Now here the tribunal, after hearing both the parties, after seeing the terms that are referred to by the complainant and the defendant, the tribunal is now giving the order to appoint a receiver, to remove any person from the custody, to give the possession, custody, or management of the property to the receiver, or confer the powers to the receiver which are required for their possession for bringing suits or defendant. So the filing of application, collection of rents and profits, preservation, realization, management, protection, execution of documents, whatever powers the tribunal they deem fit should be provided to the receiver will be granted. Also, they will appoint a commissioner for the preparation of an inventory of the properties of the defendant. So the defendant does have the right of pleading a set off, but after all of that, the next step will be the order which is given by the tribunal. All right. So they have the power to pass the interim orders, the attachment orders, and so on. We have already discussed in the previous chapters. Okay. Then, if we talk about the appeal to the appellate tribunal, when the DRT they have given an order of the recovery certificate and the defendant or any person who is aggrieved by the order that is passed by the DRT, then they may prefer an appeal to the appellate tribunal or the DRAT, which again has jurisdiction in the matter. But if the order was made by the tribunal with the consent of both the parties, then no appeal shall lie. This is very important. If the order was made by the DRT with the consent of the parties, then no further appeal shall lie. Then this appeal is to be required to be filed within 30 days from the date on which the copy of the order is received, and it will be accompanied by any fee that is prescribed. And the appeal filed after 30 days will be entertained by the appellate tribunal if it is satisfied about the cause for not filing the appeal in time. Right? Okay. Then when the appellate tribunal receives the appeal, they will give a chance or opportunity to be heard to both the parties, and then they will confirm or modify or set aside the order which is passed by the DRT. So the appeal that is filed before the appellate tribunal shall be dealt with as quickly as possible and should be disposed of finally within 6 months. Within 6 months from the date of receipt of the appeal. Also, there's no provision in the Act for further appeal against the order that is passed by the appellate tribunal. However, the exception of the writ jurisdiction of High Court is there. Then, if we talk about the deposit of amount of the debt, wherever any party they want to file an appeal to the appellate tribunal, the defendant first they have to deposit 50% of the amount which is determined by the tribunal, right? So if the defendant they want to file an appeal with the appellate tribunal, first they need to make a deposit of 50% of the award which is decided by the DRT, and without such payment no appeal shall be filed. However, the tribunal they have the right to reduce or waive such payment to not less than 25% of the amount which is determined. So either 50% or in exceptional cases 25%, right? So, okay. Next, we have the procedure and the powers of the tribunal as well as the appellate tribunal. So, the tribunal and the appellate tribunal, they are not bound by the procedure which is laid down by the Civil Procedure Code. It is guided by the principles of natural justice, subject to the provisions of the Act and the rules, and they have the powers to regulate their own procedure. So, for the purpose of discharging their functions, the same powers of a civil court under the Code of Civil Procedure have been vested. And such powers are in respect of summoning and enforcing the attendance of any person, examining them on oath, requiring the discovery and production of the documents, receiving the evidence of affidavits, issuing commissions for the examination, and so on. They can also decide on the ex parte basis, that is on the basis of the evidence provided by only one party, the decision which is given, and no appeal shall lie against that, right? Then requiring the evidence under the banker's book, appellate tribunal are deemed to be civil court, and so on. Then finally we have the limitation. So for the application to be filed before the tribunal, the Limitation Act 1963 applies. We'll be studying about the Limitation Act, the law of limitation in Unit 23 of our Module C. So the Limitation Act applies and it says that the application must be normally filed by the bank or the financial institution within 3 years from the cause of action. So when the account it actually becomes an unpaid, or the dues they actually become unpaid dues, then within 3 years from the cause of action, then application should be filed by the bank or the financial institution. This is according to the Limitation Act of 1963. So we have seen that the banks has to file the application for the recovery of the loan dues under the DRT Act which have not been paid by the borrower, taking into consideration the jurisdiction and cause of the action, right? Also, other bankers or financial institutions that are also creditors to the same particular borrower can also join the application. It will be accompanied by the fees, documents, and the evidence. Also, if the transfer is made from the civil court to the tribunal, then no fresh fee is required to be paid to effect of law. So all of these provisions are very important. Also, the procedure for issuing the recovery certificate, provisions for the appeal to the appellate tribunal by paying 50% of the amount which is determined by the tribunal, which is to be deposited. Again, if the appellate tribunal, the decision that is taken by them is in favor of the defendant, then it will be paid back to them, right? And normally within 3 years of the cause of action, the application has to be filed by the bank or the financial institution. These are the important provisions for the procedure of the tribunals. So that is all for today. If you want to join the Super Elite plan, which is the all-in-one course, so the link is there in the description box. Here you will have the live classes, mock tests, and the notes of all the papers for your exam. And this is the best course that is available. If you subscribe now, you can use the code HNY, the HNY, and get flat 52% off on your subscription. Right? So the exam dates are already out, and it is very important that you give 100% towards your preparation. So make sure that you join the course and start your preparation. And this offer ends on 9th of February. If you want to download the PDF, it is already available in the description box. Make sure that you download it. It is going to be very helpful for your revision. Also watch the other videos, the other units, and subscribe to the channel so that you do not miss any of the important updates. That is all for today. I will meet you again tomorrow with the next unit. Till then, thank you, all the best, and take care.